Okay, picture this. You're in the middle of a heated divorce or a high stakes business negotiation, and the opposing side suddenly pulls up your Instagram feed in court. You know what? That innocent vacation photo, it's now evidence that they are attempting to use against you. Sounds intense, right? Social media has become the silent witness in countless cases, but not all of it holds up in court. In this video, I'm going to be diving into what courts actually consider, what they see as valid in social media, and actually what comes into evidence in this year. So let me tell you this. Trust me, it may surprise you because it may not be what you think. So stay tuned because understanding this can make or break your case. So in this video, we're going to learn what types of social media are the most and least credible in court, how to present your digital evidence so that it's taken seriously, and the strategies to protect yourself from having your own posts twisted and manipulated and used against you. So, for those of you who don't know me, I'm Rebecca Zung. I have been recognized as one of the top 1% of attorneys in the country. I specialize in high conflict personalities like narcissists. I've been featured in Forbes, Time, Newsweek. I've been the author of Slay the Bully, How to Negotiate with a Narcissist and Win. And most importantly, I've helped thousands of people just like you navigate the toughest legal and negotiation strategies. And I'm here to give you the tools to win and get the successful outcome that you deserve so that you can break free and move on with your life. So if you want the upper hand in your situation, go ahead and hit that subscribe button and tap that bell so you don't miss a thing. So now let's go into the shift in social media evidence rules. I'm old enough, I hate to say it, but I'm old enough to tell you that I remember the time before social media in practicing law. And so when it first became a thing, it really wasn't taken all that seriously. But now it is, as I mentioned earlier, the silent witness. So it's been a huge, huge shift. And the courts are tightening the rules on what counts as valid evidence. So here's an example. Let's say somebody submits a screenshot of a Facebook post claiming it proves harassment. If that screenshot doesn't have the metadata showing when and where it was created, or if it's edited in some way, it could be thrown out as unreliable. On the other hand, if you do provide the post's original file with platform verified timestamps and location data, it's much harder for the opposing side to dispute its authenticity. It all comes down to authenticity of evidence when you're in a court of law. So the takeaway is that metadata is now your best friend. So what counts as valid evidence? Let's break it down further. Courts are looking for posts, photos, videos, and DMs that meet this criteria. Number one is relevance. Does the post actually prove something about the case? For example, a selfie showing you at a nightclub while you're claiming to be a full-time caregiver could potentially hurt you in your custody argument, especially if you were supposed to have the kids during that time, right? So the next thing is accuracy. Courts are looking for unaltered original content, something that's been heavily filtered, manipulated, cropped, something's been done with it. Obviously, that's going to raise questions and could be the difference between it coming in as evidence or being denied as evidence in a court of law. The next thing is authentication. Platforms such as Instagram and Facebook now have processes to verify evidence. So, for example, if you claim somebody made a threatening comment on your post, you may need to get the platform to confirm that it wasn't deleted or altered. So here's a pro tip. If you're gathering evidence, save the post, but also save the comments and the context around it, because that's going to help you prove that it hasn't been altered. So here's a common pitfall, or a few common pitfalls to avoid, right? So let's talk about some social media no-nos. So number one is assuming that privacy laws are going to protect you. So if you send something on Snapchat or something in a direct private message and you think that's private, it is not private, because if the courts issue a subpoena, a court order to the social media platform and say, give me all of this information, those records, if they're relevant to the case, are no longer safe from everybody's eyes, right? The courts can subpoena them and ask for them if there's going to be a relevancy to them, if they lead to something that's going to help the court make determinations about the law in the particular case. So never assume that anything that you post or send isn't going to come and see the light of day. I always say be very careful about what you put your hand to. Anything you draft, anything you write, anything you post is going to be, just assume it's a potential trial exhibit. And if you believe me and you know this is valid, I want you to put the word valid in the comments right now. And if you need help with what to document when in your particular case, I have a really special tool for you. I call it my Doc the Narc tool. Go to docthenarc.com and grab it for yourself right now. All right. Next no is deleting content. So if you are in a particular type of case, let's say it's a business litigation or probate litigation or divorce or custody, and you delete some kind of tweet from years ago because you think it could be self-incriminating or embarrassing or who knows. Well, if the other side has a screenshot of it, and you can't provide the metadata to disprove it, well, the court's not only going to know that you're lying, but they're also going to assume that you're hiding more than just this. Like, why are they hiding things and what else are they hiding? So always, always, always consult your attorney before deleting anything, because it could definitely backfire on you. All right. So how do you use social media to your advantage? Let's talk about strategy. Social media can work for you if you know how to use it. Document positive behaviors. So for example, if you are in some kind of a dispute, posting pictures of you, let's doing something good. Let's say it's helping kids with homework or attending events. All of those help you paint a strong narrative, right? And exposing inconsistencies. Let's say the opposing side says, oh, I have no money or whatever, and there they are on vacation with somebody. They're posting themselves on a yacht, hanging out. Well, and by the way, I've actually had that happen where they say they can't afford to do this. They can't afford any kind of support. And they say they're financially struggling. Posts about extravagant vacations could definitely harm them. Screenshot those posts. Make sure you have the proper metadata. And all of that will help to dismantle their arguments. Remember, your social media is a reflection of your life, and it's also a tool that can either protect you or harm you, depending on how you use it. All right. So remember to drop your comments below. I would love to know more about what you're thinking. Remember that you have the power to control your narrative and get where you want to go, and take control of your particular case, both online and in court. Social media isn't just a highlight reel. It's actually a record of what's happening. Use it wisely, and then you can turn the social media, any social media platform, into a tool for your case or for your negotiation. All right. So if you're ready for more strategies, check out my video on how attorneys prove narcissistic abuse in court. It's packed with actionable strategies to help you stay on track one step at a time and win your case and get the outcome that you want. So remember, before you go, if you like this video, like it, share it, and make sure you subscribe here and hit that bell. Join this amazing community of empowered people, empowered negotiators. And remember that today is a great day to start negotiating your best life. I'll see you in that next video.